Ladies and gentlemen, welcome to the last session of Finance Magnates London Summit 2022. Prepare your branded notebooks. In this signature London Summit session, we bring together leading experts in regulation. The session will be led by our moderator, Ron Finberg, Product Specialist Director, S&P Global Market Intelligence, Cappitech.
Thank you very much. So first of all, I'm amazed how many people are here. I already told everybody, I said, okay, this is what's going on. We are the last panel on the second day, so we have to be like really exciting and this and that. But now we can just be plain boring because you guys are already here. We don't have to bring the heat. So first of all, again, my name is Ron Finberg, and I'm part of S&P Global Cappitech, where we provide different solutions for reg reporting. And as part of that job, I get to interact with a lot of the people on the panel today. And knowing quite a few of them in the past, they are really good experts in the space, and I expect we're going to learn a lot in today's panel. And one last thing, though, we will have a Q&A section. So if you want to have questions, please prepare them, have them in mind. Everybody here likes interaction, and especially the ones that they don't know that they're getting, so it makes it funner. Okay, so we're just going to have everybody introduce themselves. Evdokia, start with you.
Hello, everyone. Thank you, first of all, for the invitation. Happy to be here. My name is Evdokia. I'm coming from Salvos Funds. We are based in Cyprus and dealing with licensing, regulatory compliance, internal audits for all the financial entities based in Cyprus, EU, and around the globe, according to the needs and the trends of the regulations and the market.
Thank you.
Thank you.
And I'm Virginie O'Shea. I'm the founder of Firebrand Research, which is similar to a Gartner or a Forrester, just to give you a frame of reference. So research advisory work, particular to capital markets. And I've been spending around about 20 years plus on looking at financial regulation, looking at operations and technology in that space.
Hi, my name's Rav Saidha. I'm the chair of the Retail Derivative Forum. The forum was set up around 5 years ago to focus on transaction reporting issues. Certainly from the beginning of MiFID II, and we currently have 40 firms made up of CFD spread bet brokers, consultants and vendors.
Hi, I'm Remonda from Muinmos from Denmark. I've been in financial services for over 20 years, similar to you, trying to find RegTech solutions for the market, in particular in client onboarding. Hopefully this session will be quite exciting, and it's wonderful to see a lot of you here today.
I am Mark Kelly. I've been working for the last 10 years on a very narrow sliver of regulatory advice, which is around MiFID and EMIR reporting. I've got a little sidebar in the last few years in the crypto space, and I act as chair of a brokerage crypto firm in Malta.
Thank you, everybody. So I've had the privilege to be moderating panels at this event for about 9 years now. I wasn't at the first one, but since then I've been involved. And often when I moderate the panels, I come up with these questions and really figure out what to do. But thankfully, in more often than none, the news of the day is what drives what's going to take place. So that being said, Mark, I'm going to start with you on your side. There's been a lot of talk about cryptocurrencies, whether it needs to be regulated or not regulated. So we'll start with something just on the basics. We know that the EU is trying to introduce cryptocurrency regulation called MiCA. Maybe just tell the audience a little bit what that is and who it's for, and what type of effects it would have on their businesses.
Sure. I was worried for a moment you were going to ask me about more recent events with FTX, which
we'll get to that. We got to create the foundation first before we could blow it up.
It's going to be like a Lehman's. It'll be a long time before all of that is unpacked, so we know what really happened. But MiCA, I'm not always a huge fan of ESMA regulation, but I think they did a pretty good job on the MiCA regulation that's come out so far. And the reason is it's got a good lineage. The MiCA regulation is like a slightly slimmed down version of what Malta has put in place very successfully over the past couple of years, which in turn is very largely based on the old FCA handbook. So a lot of the great things about segregation of client funds, about financial promotions, about issuing of new instruments has a good lineage. Very clearly laid out. There's nothing there for me at the moment on transaction reporting, or it's not clear that there's going to be any requirement. But certainly, requiring issuers of new coins to be real life firms, with registered addresses, to put out a white paper which has to include, a long list of items in it before they can actually issue a new coin is great. It shows a couple of things which are strange to me, which is a lot of the regulators around Europe are really focused on stable coins. That's not generally where the biggest risks are, but I suppose if they are the platform for trading other coins, they've got to be sound. The other thing is it doesn't deal a lot at the moment with derivatives, and derivatives is a lot of where the risk comes from in the crypto space. It doesn't matter if you've got great control over Bitcoin and Ethereum spot trading in Europe if there are 100 times leverage futures coming out of the Seychelles or Marshall Islands or whatever. So it doesn't cover everything, it doesn't handle all of the risks, but it's definitely a good step in the right direction. And meanwhile, where's the UK? In other areas, the UK has shown themselves to be very happy to be rule takers in terms of lifting and shifting EMIR rules, but there's a big disconnect in the UK between FCA patting itself on the back for turning away 80% of the firms that applied to be crypto regulated for AML purposes, and the Treasury saying we're open for crypto business, and now number 10. So there's a lot of mileage still to go in the UK, but fairly happy with the direction of travel of the EU regulation.
Anyone who just came late, there are a few seats in the front here. Please feel free to come in. Thanks for that. So you mentioned something interesting, Mark. You said part of the rules is delineates how you have to have segregation of funds. So one of what the FTX did show was how easy it was to get around having, you can segregate the funds, but how easy it was to then take those funds after you've segregated them. So maybe Evdokia, if you can kind of talk to us a little bit in terms of the MiCA, if there's policies in place that potentially could protect investors that their funds won't be segregated and then desegregated.
Definitely. Thank you for the question. I will add to what MiCA shared. We find MiCA very complete, similar, I will say, to what MiFID what they introduced. And from our side, being from Cyprus, SISEC regulations and the directives, yes, primarily they are focusing on AML, but the directives themselves, they already incorporated all of those rules on the governance, on the safeguarding of funds, and the corporate things that are coming with MiCA, which is very, very important. Because now, for example, in Cyprus, we already started the registering of the entities, where we have Binance, Revolut already registered, and where they supported the regimes. And before MiCA is in place, they are kind of forced to do all of those rules and have them there, which is good, because when MiCA will come, the regulator will not go after all of those entities to ensure that they have all of those things in place. Whereas if we are looking the FTX case, if they already had all of those in place, and the substantial amount of money that they controlled, we wouldn't have this effect.
But how would the money be safeguarded? Because now, in a traditional firm, you have a bank. You can make a request to move money from one bank to another bank, but once you get over certain limits, you're going to have problems. You have to, have additional requests and approvals for that. How is that going to be prevented in when it comes to cryptocurrencies, when it's easier to just move things around? So I know, Remonda, you're shaking here if you want to cover that.
I'm actually about to say I'm not sure that would necessarily solve the problem. And probably a lot of you in this room are aware to segregate client money, that's actually more for retail. So how is that going to be dealt with under MiCA and what's happening also in the UK? We've seen firms that went down, and unfortunately the classification of the client should have been retail, but they were not. The regulators found out afterwards, but by that time the actual firm has gone out of business. So how are you going to safeguard that? ahead. That's even under MiFID really today, let alone what's going to happen with MiCA when it comes into effect into Europe and as equivalent in UK and of course the rest of the world. So I'm not sure that's necessarily one way of discussing segregation is only looking at it as where do you put the money, how can you safeguard it. You need to look at it from the point of view is when you take that money from the client in the first place, how actually can you deal with it subject to the regulation and what are you doing in practice regardless whether it's MiCA or MiFID.
Yeah, but just to add here,
Yes.
it's about having the rules in-house first of all, where FTX didn't even had that. So they didn't even, reading all the issues that happened, they didn't even have rules to know the amount of assets, the digital assets that they were holding.
So you're saying by having more just disclosures and understanding there that becomes transparent to at least a governing body, it limits the abilities for firms to then the next day have changes there that are going to be unanswered.
Yeah, the regulations are there to kind of force you to do things, but if you do them, it protects you as well in the end of the day. It protects also the investors. Yes, you do it for the investors, but you do it for yourself. If FTX had these enforcements in place, they had to follow it. They are big enough not to do it. We want them to do it. So
I guess the way I'm hearing this is that one of the goals of regulation is to create a number of red flags that regulators could see ahead of time to be able to prevent these things. So, Virginie, in terms of changes to regulation that could take place now because of this, I know you said that there was a discussion today in the EU about this topic, but being that we're not connected to that, any other, just in terms of what you're hearing about what could potentially change?
Well, I think it's interesting. Mark mentioned a schism between regulators, and there certainly is in the US. Now, I've sat and listened to hours of House Financial Services Committee meetings talking about crypto regulation over the last couple of years. And one of the interesting things is the reason it's been so slow to pass regulation in the US, which is where FTX, I guess, is going to be prosecuted, is half of the House wants to just ignore crypto and hope it goes away. To be fair, they don't want to regulate it because they don't want to sort of turn it into a real thing, make people think that it's a reliable asset. And the other half are very keen on crypto and want to bring it into the economy and want to make it, that they're very pro-innovation, as they call it. So it's an interesting thing to see that schism, and it's also happening here, I'd say, on the two different regulators there. Which side is going to win out? I'm not sure in the US, to be fair. I think in the UK, I believe the Bank of England will probably win out because the FCA's powers are being completely undercut by the governments, which we should also mention too. But it's an interesting thing to look at the major market in the US, where there's a lot of retail investment going on comparative to here and the rest of the EU. If they go the route of trying to get rid of crypto, which they could effectively do by killing the market and unregulating it, or keeping it unregulated, what does that do with the global picture? And can crypto survive it in the long term? I'm not talking about tokenization here. I'm talking about crypto in particular, right? I think tokenization of assets, we bundle everything into one thing. I think there's a whole spectrum of different assets that people are interested in. And tokenization is certainly an area where I think traditional finance is embracing. So, but crypto, I'd say it's still the Wild West. There's a lot of Ponzi schemes out there that still need to be, crypto Ponzi whack-a-mole, I call it, that's going on at the moment.
Okay. Talking about the idea of in terms of protecting retail funds and just the whole point of the regulation is to protect investors. So we'll move on just a little bit. And Rav, I want to get your feedback on this, as also being involved with a lot of direct involvement with a lot of retail brokers. There's been a lot of changes that take place especially in the UK and EU, in terms of the leverage changes and MiFID II. Do you feel that what's taken place is actually helping retail clients, or can a retail customer now, at all the brokers here that are coming, can they feel that their money is actually safe?
I think they should, because there's a lot of regulations that have come into place to protect the retail investor, and I know a lot of the firms in the Retail Derivative Forum were very concerned when these regulations were first coming into force because of the impact that it could have. But it's kind of a bit of a double-edged sword, because you have the retail clients that will stay with the same broker, and they might end up trading less. They might trade different product sets. They might invest more of their money into the investments, or they could find a broker that will offer the products at a lower amount. And I guess we've spoken quite a bit about the cryptos, but if we move into an unregulated world for those sort of products, that will just only encourage the average client to go and find a broker that they can trade with in an unregulated environment, and we end up seeing what we saw with FTX. So I think there's pros of it. I think there's cons of it. I think it's a little bit early to judge in terms of where we are overall, but I do think overall there's a benefit, certainly to the retail client.
But other than these, offshore regulators becoming more strict in their standards, is there any way to prevent what you're talking about? Like, you're always going to have, if firms are going to be looking for a higher leverage or new products that they can't trade in the UK, how do you prevent that? What can be done in the UK or EU to prevent those customers from leaving and going offshore?
I think regulations can be put in place to try and stop that from happening, but there's so many ways around it. And with technology in this day and age, you could use a VPN to sort of hide where you're trading from, and it's a really difficult problem, I think, for regulators to keep a handle on. I personally don't think regulators saw what would be happening with cryptocurrencies. I don't think they anticipated that the volume would have increased so quickly. But if you think over the past year, how many people have tried to jump onto the Bitcoin bandwagon, certainly in the UK that wasn't possible for them if they're a retail client. So they've tried to explore other avenues, and I guess that's where the risk is.
So I'll be curious to hear people's feedback on this. But one of the items that I've kind of found, wandering the halls today and in some previous events, is perhaps it's not necessarily the clients that are looking for the offshore firms, but the way that marketing now, you have more restrictions on how you can, corporate governance. You can't market in certain ways. You can't use certain affiliates to bring you customers, but you could still use those things on other jurisdictions. So it seems to be perhaps that the funnel, it's not the clients looking for things, but the funnels that existed up to a few years ago have been blacked out from the EU and UK, and now are moving things to the offshore, and that's so. Remonda, I know you do a lot with KYC in AML, and you have your hands involved with a lot of these client onboarding. So what's your view on this?
I think on this particular issue, what could be very, very interesting is if you look at the risk warnings that every firm is supposed to present to the clients, retail or otherwise. It has to be there, it has to be obvious, they have to be able to see it, even accept it and so forth. What I don't understand is why don't the regulators actually make specifically a requirement that every firm that's taken on clients outside their jurisdiction, where they should not be taking them, where there is actually a clear disclaimer that states, if we go down, we shut down, we're criminals, we're whatever, it doesn't have to go to that level, we actually you will not have any recourse to any compensation scheme. And I think there are many clients out there, retail and higher-end clients, that all of a sudden, when a firm goes down, they go straight to the compensation scheme in the relevant jurisdiction and basically say, our money should be segregated, we want X, Y, Z, and we should never have traded in the first place, therefore reverse everything we've done. And of course, there is nothing for them. So I actually do feel that the regulators can step that up as well. But of course, which regulators? And some of the offshores are beginning to do it.
But just understand what you're proposing. You're proposing that the UK should say to a UK broker that if you have a Vanuatu entity, on that we're only going to give you by being regulated in the UK, your other entities have to have disclaimers there as well.
Well, no, because they wouldn't have jurisdiction over it, so they wouldn't be able to do it. But of course, a lot of the offshore jurisdictions are beginning to go through a lot of cleansing exercise. In particular, look at Cayman. A lot of people in this room probably have had some form of meetings with them if you have some sort of presence in the jurisdiction. And actually, they can say, if you are taking on clients from outside this jurisdiction, they allow them to do it. In the UK, you actually can't do business outside your licensing requirements. So they can't tell them to do it.
So you're looking for more standardization across the regulators.
And education to the clients that are actually trading offshore, if you like.
Okay. It's an interesting idea, and we know, kind of moving on here a little bit, for transaction reporting, for reg reporting for EMIR and in MiFID, there is a bigger move to kind of standardize different things across the globe. So Virginie, I can go back to you. Just like what's I know you were doing a lot of work lately on the CFTC and preparing firms there. They have a new go live with the update. So maybe you can just tell us a little bit about what were the experience of firms getting ready for those changes there. And
Sure. I mean, you talk about regulators getting on the same page. Never going to happen. Unfortunately, you look at...
Thanks, you. I didn't want to say it directly, but someone else did.
I can. Fully happy to say that. But if you look at the CFTC versus EMIR rewrites, they're about 49% in the same in terms of the fields. I mean, I know that's progress from where we were before, but that's not really that much progress. You kind of want it to be a bit higher than that for people to be able to report globally in one hub. It would be much more helpful if there was more overlap. And to put it into the context of the fact that people were supposedly working together at the regulators to be able to do this, but again, divergence, politics gets in the way, and practically they change the way that reports have to be delivered as well. So in terms of preparedness, I think obviously there's the move in the US from what used to be a very sort of principles-based regulation under the CFTC has now become very prescriptive. It's looking very much more like EMIR in Europe, which has had its own issues. It doesn't have dual-sided reporting, which was one of the horrors that we had to deal with here. But in terms of preparedness, I think firms are quite shocked in the US about what's coming down the pipe from them. There's a lot of communication across the lines there between Europe and the US internally within financial institutions to go, how the hell do we deal with this? But when it comes to EMIR refit, I think there's a lot of practical... I'd say they're trying to make it a little simpler, whether that happens in practice or not. That was the goal of EMIR refit, was to try and simplify some of the troubling aspects of EMIR. I think we've come up with many more fields and many more changes that to try and reach that goal. Whether that they've achieved the goal of making it simpler or not is another matter entirely. I'm sure Mark also has a view on that. But
yeah. So Mark, just on that as well, like I know you've worked with a lot of firms as they've prepared for MiR, MiFID 1, MiFID 2, just over your career. Is there any, knowing that there's going to be changes in Australia, Singapore, Japan, in addition to Europe and the US, what do you tell people in terms of what to be looking out for as they prepare for it?
I think there are a couple of challenges for compliance officers trying to get focus on some of these incoming regulations, and one is it's not happening for a long time. There's a very long lead time, and every IT department has got a number of fires that they need to deal with urgently. They're not going to be setting aside funds and starting to analyze, because first thing they'll say is, where's the spec? Well, we haven't really got it yet. We don't know whether you're going to have to generate XML or whether the trade repositories will take in CSV files and they'll generate the XML and pass it to themselves. It's all a bit up in the air. Not going to get any budget on that side from IT. You go to the senior management and you say, we should really be worrying about this stuff. Why? What's happened? Well, there was a fine, £500,000, and a couple of people got banned from working in the city or having a regulated position. Okay, what did they do wrong? Well, back in MiFID 1, and it turns out it was five years ago, the things that people are being sanctioned for now. And again, the CEO probably thinks, well, I'll be retired before they ever come after me. So there's a kind of lack of urgency in the consequences of getting it wrong, and there's a lack of urgency in the time frame for preparing for the new things. All makes the compliance officer's job very hard to get attention on these things.
And it doesn't help that ESMA are very slow at producing the regulatory technical standards. Sometimes we get them just before implementation, right, or some of the operational guidelines. And Q&As keep coming. It never stops.
I think 2024 is going to be a very interesting year. There's loads of new regulations coming into force. The biggest concern that we've certainly seen as a forum is the divergence in the regulations. I think when this was all first being discussed, it was almost like a dream. everyone's going to be doing the same thing. But then very quickly that started changing. And you really do need to look at the requirements from each of these jurisdictions, because they aren't always the same. We've certainly had discussions with ASIC where they have differences in their interpretation of the rules versus ESMA. We're still waiting on the FCA's feedback on their consultation paper. So going back to Mark's point earlier, 2023 is kind of your prep year. That's where you need to figure out what you need to put in place to make sure that you're ready for 2024. So I think it's going, if you're not already looking at it, you definitely should be.
When you talk about divergence, I know there's a technical aspect, but then you brought up, like the ASIC and ESMA are defining the same fields differently. Do you believe we're getting to this point where where firms that are more global can no longer be consolidating their expertise and their reporting? It has to have your Australian experts that are just focusing on this, and then in the EU, or can you still have that global, that single global approach?
I think it's hard. It's no longer the case. You do need to look at what is happening in ASIC, and there are edge cases that are different to MAS, different to EMEA, and so on. And it's definitely not what I think the regulators thought they were going to achieve at the end of this. And we haven't spoken about UPI, which is another fun one that will be coming through. And I know the CFTC have been quite involved in getting that for them as well. But there's a lot of change happening, and because the regulators are not all implementing it in the same way, it is making it difficult for the broker.
Okay. So one of the things we'll ask finance magnates, they often do little breakout videos. So maybe to Mark, as you're saying, internally people need to know that there's a fire coming. So maybe we'll create a little 4 or 5 minute breakout video here that you could share with your CEOs to make sure you get those budgets and the awareness in your companies.
With a little bit of fire in the background.
Good editing. There's a lot of marketers here, so we can do some editing and get them involved. Moving on to other areas, and kind of a little bit back to what we were talking about before about licenses. So in terms of offshore and different things. So I've, you hear about different companies, different openings, change of management. So Evdokia, I know we talk about this often in different panels in different locations, but I feel I go back to this question often because I feel like it's something that changes often. So like right now, what's the status of getting a new license? If you want to register for a license in EU, UK, or Cyprus, where you're, what's the wait time? What do you have to be getting ready for?
Yeah.
What's changed in the last 6 months?
That's a very interesting question. And as we deal a lot with licensing, and we are specialized in Cyprus, but we are dealing with clients all over the world. So we are dealing with offshore licenses and everywhere. So one of the things that I will say is people, they want something, they want it now. And when they go to any country they say, I want a license and I want it today. Unfortunately, this is not the case. You have to wait. You have to, first of all, complete all the due diligence in order to file an application and the business and all of that. And then you have to wait for a period of, let's say, a year in any jurisdiction that you go. And the people do not understand that.
When you say any jurisdiction, you mean in what we call like the onshore, or even in like some of the other offshore markets as well?
We consider that, let's say, if you want to go to EU, we consider that CISEC is one of the most friendly obtaining a license in EU. Okay, when you go offshore outside EU, including FCA, and then you go and you say, okay, which are the friendly, let's say, jurisdictions, compliant, less compliant, leverages, and all of that. At the moment, we consider that Seychelles, Mauritius, let's say, are the ones that are regulated and friendly ones, and you can do your business. And then if you want more prestigious, you can go to Dubai, which is increasing a lot, Abu Dhabi now, where we can see a lot of clients going there.
But what's the wait times in terms of those?
Exactly.
It's also Europe?
That's the thing. It's a lot of waiting time. With only now, currently, the only attractive jurisdiction where we see, it's Mauritius, where you can obtain a license much quicker than that. Let's say you can get it in 6 months. And the reason we see that is because they are outside now of the high-risk jurisdictions on the AML for the last, let's say, 6 months, where it's not a pipeline of licensing there. Whereas if you go to Seychelles, and everyone was going to Seychelles, it's a pile-up of applications there. So we see, as you say, every 6 months, a shift of the licenses. However, many groups, what they do, we actually go and they say, okay, I'm going to take as many as possible because things are changing.
Right. Okay.
Yeah.
That's but I find it interesting to hear from your answer that we're no longer in this turnkey regulation where you can get something up and running in a few months. You definitely, no matter where you're doing, you have to potentially be planning for a year. And I know, Remonda, one of the items is that a lot of firms have to have have their ducks in order. I know that's our ducks in the booth. I didn't just say that. But you have to have your ducks in order before you get ready to go. In terms of AML and having different policies in place, what does that mean in terms of preparing before your license?
I think my biggest concern right now wouldn't be which regulator does it in 2 minutes or 5 days or 1 year. More if you can even keep it afterwards. You will find these days, I don't know how many of you are following what's happening, but look at the BaFin in Germany, look at the Dutch regulator, look at the French. They're almost killing the passporting regime due to some significant failures of other regulators, even in the European Union. So that could potentially mean that even if you get regulated in a jurisdiction in Europe and you hope to be able to passport your services into another European member state, those days may not be long-lasting, to be honest with you, in the next year or two. So I think one of the biggest concerns I have very often when we talk to clients having multiple different jurisdictions is, do you have them to avoid these wait times, or do you have them to protect your investors, or do you actually have them because you do have different client segments in different jurisdictions where you would like to service them in the best possible way? So I think from our angle, I would definitely be a little bit more cautious about where you go and get regulated. Even in Europe, it's not safe grounds anymore.
I think it's very time-consuming to go and get a fresh license anyway. And talking to Ron earlier, we were talking about the option of just buying an already regulated firm. That saves you a lot of time.
You also have the change of ownership, though.
You've got to fill in forms for the change of ownership and get. That's generally a quicker process than applying from scratch. But very often, there's a reason why the firms are up for sale, and you will find you've inherited a whole host of problems and sanctions and things that you don't see on the surface once you get them up and running. So there's no completely satisfactory shortcut to getting up and regulated. In terms of Ron's earlier question about are the regulators doing a good job of protecting retail investors, I know that they've taken some products away from me on the various platforms. I can't do CFDs. I was very happy with the 2 times leverage on crypto CFDs. That's gone. On the plus side, I'm not getting plagued every 5 minutes during the day by binary options firms, which was happening at one time. But I think it's not protecting the retail investors. I think it's protecting themselves as regulator from sanction and from taking a slapping from the government. Because in a lot of cases, they're just pushing the problem offshore. They're not stopping people opening an account with BitMEX at 101 times leverage. They're just saying, not on our doorstep, because if we let you do it here, then we'll get the fallout.
Just to add a bit on the acquisitions, because we deal a lot with the acquisition side, I agree with you that it's about what we want to do. Many people, they want the licenses you said today, which is nice. It's the time value that you gain. And the profit considerations that you can, let's say, start the business today until you get the change of ownership. But again, you have to do a deal with the seller in order to operate, and there are risks for both sides. However, you can find a middle ground. The problem that we see from being as consultants in there is about, first of all, the right people to consult you there in the acquisition phase, and whether the regulator sees the company as being dormant in a way. So many firms, let's say, they go to SISEC, they apply, they get the license, and then they find all the costs and all of that too much. So they want to sell it. But from the side of the regulator, maybe they see like a non-operational license where someone selling it. But they don't like that. So they want to see operations. We sell a business. We don't just sell a license. So this is changing, and it's something that investors need to think about.
So potentially it's easier to buy a company that has an existing operating business and not just a dormant license.
Yes, definitely. Whereas most of the people, they want to go and say, I want a company with no clients, just the license, which is fair. You don't want to inherit the problems. But when you go to the acquisition stage, the regulator will say, wait a minute, we just went through the whole due diligence to authorize you, and now you are selling it, and you maybe make a premium of $500,000, and what do we gain? We just, we don't sell a business.
Okay. I'm going to take a complete U-turn over here and go to a very big, different topic. And it says here, regulation, what you need to know for 2023. So we're going to go into the future regulation now. So how many people in the audience are familiar with ESG and potential regulation under ESG for SFDR? With a show of hands. Not a lot of people. Okay, so perfect. So one of the new movements that's taking place across a number of different regulators is to introduce, just like we had for MiFID II, different governments and way how for PRIPS in explaining what the products are, the investment risk. So there's a lot of new disclosures that are coming about on the ESG, the environmental, social, and governance. So I know, Virginie, you're involved with this a lot. So maybe you can just give everybody a little bit update on what regulation is coming and how this could affect people in the audience.
There's a lot coming. There's many different parts to this. So there's not just one regulation. Everyone sort of references SFDR. There are other bits to it, right? Including corporate disclosure, which is CSRD, not CSDR. There's many.
Is there a good sustainable finance? Is that the name that we should be calling it, or is it everybody has a different name as well? Or?
Again, you can't put it under just one bucket because there are so many aspects. Okay. The E, the S, and the G are all very separate as well. That's one thing to bear in mind, that the regulators at the EU level and in the US and here have focused largely on the E thus far. We have not had so much in terms of the S, in terms of how to look at it from a taxonomy perspective. So there's the taxonomy directive, which is another thing that at the EU level is trying to set the benchmark for actually what E, S, and G means in practice. A lot of this has been related to things like carbon emissions and things and disclosures of that nature. They're already fairly well established, I think, in terms of carbon and understanding that. But there's such a lot of different things under the E bracket, including things like biodiversity in sea life. How are you impacting that as an organisation? Issuers across the EU are going to have to do much more reporting on a regular basis on this topic. That could include your firm. It probably will, because it encompasses private markets at the end. I think that's 2026, so not 2023, but it's a few years off. But certainly we're going to have a lot of regulation on this front. Most of it's around transparency to the end investor, so making sure that the end investor knows if you label something as ESG, whatever it means when the taxonomy regulation's been put into place, that you actually, like the Ron seal, it does what it says in the tin, like the Ron seal advert, right? So what's interesting in terms of enforcement, in the US we've already had 2 enforcement actions. One happened just yesterday. And the regulation isn't in place yet. Go figure that they've actually enforcing things around ESG under a previous regulation, the Fund Names Act. So certainly this is a hot topic. Regulators are on it at the moment. I would say that they are trying to prove a point here, particularly at the EU level. BaFin, likewise, went after DWS. They did an investigation into them, and SFDR has not come into force. So interesting to see enforcement actions being taken ahead of regulations being set into place.
So if we go back just in terms of the audience and just like in CFDs, to just understand, so if a firm has is advertising, in their single shares. Now you have firms earning like the tech shares or different areas of, if they're saying they want to show, okay, Tesla and Apple, and these are environmental friendly shares, and they'll have that as a page to promote to their customers. Would that be something that falls under this, that now you'd have to have different disclosures when you're promoting it?
Yes, absolutely. So there's the entity level side, so making sure that you're disclosing as an entity and out to the market about what you're doing around these topics, and there's going to be a lot of scrutiny of that nature. And then there's the product side, and the product side is a little bit further behind, but certainly in terms of the regulatory progress. And there's nuances between what's happening in the EU and the UK on that front, and the US is a complete different ballgame. So it's an interesting way to look at it, is anything that has an ESG label on it is going to be investigated. And the fund managers have been sort of in the frame to begin with, but everybody in financial services is going to be under scrutiny on this front.
Okay. Did you want to add something?
Yeah, definitely. SISEC already started implementing this in the product governance. So all investment firms, let's say, they have to update the policies on that front, which came effectively into force yesterday. But then, we have also the SFDR, and we also have the disclosures under Pillar 3, which are going to come in May for this particular year. So 2023 will see changes in the fund managers, as we mentioned here. And it's a fine line, because it's not about only data that you have to do. You have to disclose to your customers, and you have to also focus on the remunerations that is subject to the ESG.
Okay.
Yeah.
Thank you.
I've learned a few new acronyms just today, but here's another one that's coming up fairly soon at the EU level, which is DORA, D-O-R-A, which I believe is Digital Operations Resiliency Act, and that will cover what kind of safeguards you've got, so that your website and your exchange can't be hacked, and you can't be brought down, or if you are brought down, you can get up and running swiftly again.
Okay.
There's also incident reporting on that front as well. There's a certain time frame. If you get hacked, you have to disclose it to the regulator.
Okay, we have a little timeline here that you guys don't see, but we do. So we're running on the last couple of minutes over here, so I want to now give it to the audience for questions. If you raise your hand if you have a question, or scream it out if you don't want to raise your hand, All right.
If there's nothing, I'll just...
Hi.
Yeah, we've got one.
So I'm the MD for a FX brokerage firm, but we're in the deliverable FX space, B2B, so working with corporates. And we have gone through regulation in the EU through Lithuania. It took us 2 years to get our EMI license, and it's taken us another almost 2 years to get our brokerage license, but most we get till next year. So going on to the question of passporting, because we are serving corporates, are you also saying that the passporting, most probably in Europe, could affect us going forward?
No, it's not necessarily going to affect you potentially out of Lithuania, but one ending I would like to make anyway from our side. The problem we're having right now in Europe, there's a lot of aggression amongst the regulators. There's a lot of which one is better, which one is there to really protect the investors, which one is there to scream out loud, and it becomes almost the, if you like, the rule book in the European Union. And of course, the obvious examples we're seeing, the German, the French, the Dutch are very often loud screamers. But the problem we're seeing right now, they're not just saying, we believe what we're doing is right and ESMA should follow it and make it almost across the entire European Union. We're actually seeing them almost trash each other. That's new. That's very, very new this year. We're seeing them almost say, you're to blame for what's happening in my country. We don't want to do business with you. We want to actually avoid you having a passporting right in your jurisdiction. For example, in your case, if all your clients are Lithuanian, there is no issue. But if 90% of your business is not in Lithuania, is there an issue? And that's actually exactly what we're beginning to see in Europe. And that's new. And that's interesting. And I think we're going to see a lot coming out between now and 2024.
Any other questions? No? Okay. Mark, you had a last point? You
Yeah, no, I just wanted to go back to that thing about how safe is people's funds in the crypto space. And there's kind of two tiers. There's a technical tier and there's the policies and procedures. A lot of the regulation only addresses the policies and procedures, and you can have those in apple pie order. Then someone who knows the keys can just go and steal the funds, basically. So there are some techniques and some infrastructure coming in from people like Fireblocks that will allow a kind of dual key thing where things can actually be segregated genuinely, so that the firm themselves can't get at the funds once they're in there without the collaboration of the investor, which is great. So you can put things in place which will increase the level of confidence in that. Having said that, you go to a lot of the exchanges and they will say, as Coinbase said to the SEC, if we go down, all of our clients, it's not really segregated. They are unsecured creditors of Coinbase, and you can expect it to take years to get the money back.
As we're just getting to time now, so I want to give everybody a couple of takeaways as you're going, just to kind of go effect. So Evdokia made a really good point that when it comes to saving, to kind of safeguarding funds, a lot of the regulation, and really what it does is it helps firms create these certain standards to kind of create these red flags for regulators to know if there's something's happening in order to prevent the next FTX. Virginie gave a lot of information about just preparing. Now is a good time to start reading about the ESG regulation. If it's not on your radars, it should be there. Rav's a really big believer that the regulation that exists in the EU and UK does help keep retail investors' money safe. However, it is driving things offshore, which could lead to other changes taking place there. As Remonda mentioned at the end, there is a difference of opinion between regulators, which could become a bigger topic in the future. Hopefully it doesn't. What you say there is a little scary if suddenly you're going to get X'd out there. And then Mark, he raised the fire over here that you have to, if you're in the reg reporting space and you have to be preparing for that, start, making a muck now to go get that budget and preparedness for it. Thank you, everybody, for being part of the panel, and thank you, everybody, for showing up. And I think this is the biggest audience I've ever seen at the end of the day, even in the middle of the day sometimes. So really appreciate everybody being here.